Good afternoon. I would like to welcome you to the training session on the judicial steps to follow after the prosecutor files to the pre-trial chamber request for the issuance of warrants of arrest or summons to appear. This is the first time we have the opportunity to hold a training session using a web streaming technology. We are very pleased that 44 national and international journalists and 21 members of the civil society organization have confirmed their attendance today. Due to the nature of the web streaming and unfortunately inexistence of software to support interactivity with such a large number of viewers, your participation is limited today. However, please rest assured that we have taken measures to otherwise maximize your experience. During my recent visit to Kenya, I have collected the most frequent questions I have received from journalists, but you also had the opportunity to send your question via SMS and emails. I can assure you that all these questions were gathered and will be answered today. Today, we have a great and unique opportunity to have the legal members of the pre-trial chamber to speak on the topic. They are ICC legal officer Mr. Gilbert Biti, and legal officers Mrs. Eleni Haitidu and Mohamed El Zaidi. Without much ado, allow me to start this session. I have grouped all the questions that you send into a topic, so it would be much easier for you to follow. So let's start. Mr. Biti, why is the ICC in Kenya?
Well, actually, for the ICC to start an investigation in a country, there are three ways, three trigger mechanisms in the statute. The first one is to have a referral from the Security Council under Chapter 7 of the UN Charter. The second one is a referral from a state party. And the third one is the prosecutor starting an investigation proprio motu, what we call an Article 15 proprio motu request to the pre-trial chamber. For the first time in the history of the International Criminal Court, in November 2009, the prosecutor, for the situation in Kenya, after having received information and having decided that there was a reasonable basis to proceed with an investigation in Kenya, presented a request for an authorization to pre-trial chamber 2 in order for the pre-trial chamber to authorize or not this investigation in Kenya. In March 2010, 2 out of 3 judges decided to authorize this investigation because they decided that crimes against humanity were committed in Kenya between 2005 and 2009. Only 2 out of 3, because for the third judge, there were no crimes against humanity committed in Kenya, as those crimes were crimes which should stay within the ambit of national jurisdiction. That's why the decision of pre-trial chamber 1 on 31st March 2010.
Thank you. What is the mandate of the court?
Well, the mandate of the court is circumscribed and defined by the prerequisites as enshrined in the Rome Statute. The mandate of the court is, very generally speaking, to investigate and prosecute the most serious crimes of concern to the international community as a whole. And when is that the case? When do we speak of those most serious crimes? For that, we have an indication in the Rome Statute because it enlists those crimes. The categories comprise genocide, crimes against humanity, and war crimes. There is a 4th crime category enlisted in the Rome Statute, the crime of aggression. There we had a review conference this year in Kampala, Uganda, where the states, the drafters of the statute, agreed on a definition of the crime of aggression, which was previously, until now, not defined in the statute. So they agreed on the definition. Once it is incorporated, formally incorporated in the statute, the court will be able to exercise jurisdiction over that crime as well and will complement the court's mandate with regard to the crimes.
Thank you. What will happen if the Kenyan government decides to establish a local tribunal? Can the ICC withdraw in that case?
Well, if the Kenyan government decided to establish a local court, that's a right for the state. As we know, it's the primary responsibility of national courts to deal with their own cases. Of course, what would the ICC or how the ICC would react, this depends on the purpose of establishing such a tribunal or such a local court. If the local court is there to deal with certain other crimes that the ICC is not dealing with, then we will share the responsibilities on the basis of the principle of complementarity between the domestic courts and our institution. If the purpose of the local court is to take over and to deal with the cases that are under consideration by the ICC, then the local government needs to show that there is a genuine effort to investigate and prosecute those cases that are under consideration before the court. And if it turned out that there is a genuine investigation, prosecution, and trial in relation to the relevant suspects and the same crimes, then the ICC can defer to the domestic efforts. And of course, there is a set of procedural mechanism enshrined under the statute whereby the ICC can defer to the domestic jurisdictions and renders the cases inadmissible.
But the ultimate decision is on the judges.
Of course.
Thank you. Apart from ICC relying on state parties to arrest the suspects, which are proving difficult, especially with African countries, what other assurance do we have that Kenya will really hand over the suspects? I can imagine that the ICC does not have police of its own, so what really happens? This was the question we received from Eldoret journalists.
Well, of course, as you know, the ICC is mainly relying on cooperation of states. Of course, we know that there are some problems with the African Union and some African states and the difficult positions we're facing. If the court did not receive cooperation from certain states, there is not much to be due other than making findings on failure of non-compliance. If the state is a party to the statute, then it is under an obligation to cooperate with the court. If it failed to do so, then the next step, maybe there might be a decision by the relevant chamber making a finding of non-compliance and referring the matter to the Assembly of State Parties to take steps further in that respect. Of course, we can rely on other sources for cooperation aside from states, such as intergovernmental organizations, for example. We can, if we entered into some agreements with those organizations, perhaps we can get some support in order to arrest the requested people. If at the end of the day we do not receive such cooperation, there is not much really the court can do. As you correctly said at the beginning, the court does not have police force. Thank you.
Thank you. Can you give us some sample of good cooperation the court has received in the past in terms of arresting the suspects?
Well, we have the most recent cooperation from the government of France of arresting Mr. Calixt in the third case in the Democratic Republic of the Congo, and that's best exemplifies that some states, when they are willing to cooperate, they can do so. There are other situations when we did not receive cooperation, such as the situation of Darfur, for example. So far, the court has not received much cooperation from the government of Sudan, with the exception of the beginning or the initial stages of the proceedings. But of course, you know, due to the political implications involving this situation and the sensitivity in the region, now we ended up having little support, let alone no support from the Sudanese government in that respect, which is understandable, of course. Thank you very much.
Thank you. So now we're going to move to a bit more procedural questions. Can you please explain in which stage are the proceedings in relation to the situation in Kenya at this moment in time?
At this moment in time, we are at the stage of the investigation in the situation. So for the moment, the prosecutor, although he says that he will soon do so, has not done so, has not individualized, has not presented any request against a specific individual, either for a summons to appear or a warrant of arrest. When that will be done, we will start the stage of a case, of a prosecution. For the moment, we are in the investigation of the entire situation, which has been defined by the pretrial chamber in its decision of 31st March 2010, which is crimes against humanity committed in the territory of Kenya, the entire territory of Kenya, from June 2005 until November 2009. This is the scope of the investigation in the situation. We are waiting for the prosecutor to come with concrete requests to prosecute some people.
Can you please answer, you mentioned the date, June 2005. Can you say why as of that date?
Because that's the date the statute entered into force for Kenya.
Will the prosecutor target those who actually organized the violence as opposed to those who it would be easier to link due to evidence available? This is the question we received from journalists.
Well, actually, of course, as a matter of prosecutorial policy, and although it's not for us actually to answer on behalf of the prosecutor, but as members of the court, we'd say that the prosecutor will have, of course, to go against those who have organized the violence, as well as those who he find evidence that supports his findings that those people are involved. So it's not a matter of question of which is easier or how can it be easy to go after certain targets even though those people who are may not be involved. Rather than he will need to focus on those persons who are directly involved and where there are sufficient evidence to go after those people. If he failed to do so for whatever reason, there is another review which comes from the chambers to make sure that the evidence presented by the prosecutor is sufficient, either to issue warrants of arrest, either to confirm charges, either to convict the persons beyond reasonable doubt, etc. Of course, depending on each stage of the proceedings. Thank you.
When and how does the prosecutor apply for a warrant of arrest or summons to appear?
Well, when the prosecutor applies for a warrant of arrest, of course, we have under the Rome Statute different stages. The first stage, that the prosecutor receives certain information, he starts conducting his preliminary analysis. And once he have identified that there are reasonable bases to proceed or to open an investigation, he will take that decision. And he finds sufficient basis in order to apply for a warrant of arrest or summons to appear before the chamber. Then he will come before the chamber by way of writing, requesting the issuance of a warrant of arrest or a summons of appears, depending, of course, on the evidence and the information presented. That's in relation to when. In relation to how, this will be, as I said, by way of writing, approaching the chamber in writing, making his request, and then the chamber will decide afterwards.
Once he files the request, is it the practice that he submits all the evidences which will be public, or it's the practice that they're all confidential?
What he needs to come with is a concise statement of facts. He will come with a summary with the evidence. Of course, what he comes with at the stage of the warrant of arrest is not going to be the same amount or type of evidence that he could submit or furnish the chamber with at later stages, such as the confirmation of charges or such as the trial stage. Of course, every stage, depending on the level or the threshold required, the prosecutor will be required to submit or to prove his case with more evidence.
And who is to decide on whether to issue warrant of arrest or summons to appear?
It's the chambers. It's the judges who decide whether to issue those warrants or summons to appear or not.
And what kind of decision judges can bring?
Well, the judges could either accept to issue the warrant of arrest, they could reject, they could alternatively request approve the issuance of a summons to appear. Or they can go back for more information, requesting information from the prosecutor, and then they can decide finally which way to go.
I think there is a bit of confusion in Kenya. People don't really understand what does it mean summons to appear. Can you explain a bit what actually means summons to appear and what is the warrant of arrest?
Well, the main difference actually between the summons to appear and the warrant of arrest is the issue of deprivation of liberty. Both documents actually requires the presence or that the person comes before the court. But the method through which you bring the person to the court is different. In relation to the warrant of arrest, the person will be deprived of his liberty. In relation to the summons to appear, you are asking the person to voluntarily come to the court and to answer in relation to certain questions that the chamber will pose. So these are the main actual differences between the warrant of arrest and the summons to appear. The summons to appear as well or the chamber may issue a summons to appear with some kind of restrictions, okay? And those restrictions could be in relation to the movement of the person in his territory or outside his territory, his contact with certain type of people. He could be deprived by order of the chamber to contact certain type of people. He's not allowed, for example, to get in touch with victims, whether directly or indirectly, etc. So there are some restrictions that could follow the summons, but not the issue of detention. And that's the key factor between the differences between the two documents.
What is also important to note is that when you issue an arrest warrant, with this actually you also request the state to cooperate with the court in as far as that person needs to be arrested by law enforcement agencies, by the police, etc. With the summons to appear, you actually serve the document on the person directly, okay? So there is this contact with the person who will accept to come to the court on a voluntary basis.
That is true.
Yeah.
That is.
What would happen if a person refused to come?
Well, if the person refuses to come to the court, what's going to happen that the relevant chamber may replace the summons to appear with a warrant of arrest and then request the state to arrest the person.
In that case, does prosecutor needs to apply for warrant of arrest, or pre-trial chamber can on its own initiative change?
Well, the prosecutor needs to apply to the chamber, informing them about the situation, and then the chamber would automatically consider the matter and may replace the issue of the summons with a warrant. There is another situation that could happen, that the prosecutor could actually approach the chamber with a request for a summons, and the chamber decides to go with a warrant because the chamber is not convinced that the information furnished to the chamber is enough or sufficient to secure the presence of the person before the court. And this happened, I think, in the Darfur situation in relation to in the Haroun case, where the prosecutor requested initially to have summons to appear. The chamber rejected that and said it's not enough in this case, given his position, to secure his presence before the court, so they instead opted for a warrant of arrest.
Okay, so it's important to remember that it's ultimate decision with the judges, yes?
A precision. What the chamber could do also is to say, Mr. X, you have to come before us on this particular date. If you don't come on that date, and that's in the summons, we will issue a warrant of arrest. In that case, the chamber can do that directly. Because the person is on notice that he has to come that day. If he doesn't come that day, then the chamber will directly issue the warrant of arrest.
Okay. Can you give us some sample from you mentioned the Darfurian situation of a case where we had actually issued a summons to appear? And what happened with that case?
You want a sample of
we
situation?
Had a practice. Yeah, we had actually a recent.
Yes, we have the Abu Garda case. That's the most recent one, where the chamber directly issued summons to appear, and the persons came before the court.
Yeah, and can you give a bit of what happened with that case?
Nothing. The charges were not confirmed at the end. The chamber decided, after reviewing the evidence, that there was not enough to charge the person and to confirm the charges against them.
Okay, so in this case, actually, prosecutor came and asked him for summons to appear, and he provided the evidences. The case moved to a confirmation of charges stage, and the judges decided...
Exactly, on the basis of the evidence presented, that there was not sufficient evidence to have substantial ground, or to meet the threshold of substantial grounds to believe that the person committed the crimes.
Okay, and can we have, I think, a last question regarding the summons to appear? A warrant of arrest is how long would judges need to decide?
Well, this will depend on the amount of evidence presented, depend on the process, depends whether you will go back to the prosecutor with certain inquiries. Well, the range would be between 2 and 3 months, generally.
Can you give a sample of another countries, how long it took in other countries? I think Uganda was 3 months.
Uganda, five persons were at stake. It took 2 months in the Lord Resistance Army case. Lubanga case, it took 1 month. Al-Bashir case, it took 7 months. Kalix Tembarushimana case, the last case in the DRC, it took 5 weeks. So it really depends on the amount of the evidence. Logically, it's not less than 1 month. it could go up to 7 months, depending on the amount of the evidence, as my colleague said.
Okay. Can we just say something about the warrants of arrest? Because we still don't know whether the prosecutor will file warrants of arrest or summons stop-here, file request for it. So can we have a sealed warrant of arrest or public? Or can you explain a bit possibilities that he might use?
The prosecutor may decide either to apply for a warrant of arrest under seal or for a public warrant of arrest. It is for the prosecutor to decide what is the level of classification. Of course, once he has decided on that level of classification, it is then for the chamber to decide if it maintains that level of classification. So the prosecutor may very well apply for an under seal warrant of arrest, but he has to explain why he needs a warrant of arrest under seal. If it does not convince the chamber, then the chamber may say, well, there is no need to issue a warrant of arrest under seal, and I can issue it publicly.
About the seal warrant of arrest, actually, we have received one question from Kenya. And it says, what assurance do we have that the government will not leak the information once notified the names of the suspects that have to be arrested? So basically, can you explain the process? How does it work? Actually, pre-trial chamber issue warrant of arrest which are under seal, and then there is obligation to notify whom and how.
Alors, logically, this warrant of arrest goes together with a request for arrest and surrender. The warrant of arrest is one of the documents that makes actually the request for arrest and surrender under Article 91 of the Rome Statute. It goes to the state where the person is. It can also go to all the state's parties. It can go to all states where apparently there is a possibility that the person will travel. So there are different possibilities. It's for the chamber to decide. We can request that state to maintain the confidentiality of the request. But at the end of the day, it's for that state to respect what the court is asking that state to do. We can ask, but it is for the state to enforce. Once again, this institution, as far as enforcement is concerned, is mainly in the hands of the state.
Can you explain the confirmation of charges stage of proceedings, and please indicate how long that usually takes? This is the question we received from the civil society organization.
Well, once the person is arrested and is transferred to the court, then actually we speak of the pretrial proceedings. The pretrial proceedings starting from the issuance of the arrest warrant or the summons to appear until the end, when the pretrial chamber will issue a decision either to confirm the charges or to decline to confirm the charges or to adjourn the hearing and then to decide anew on the charges as presented by the prosecutor. This phase is called the pretrial stage, and we sometimes informally speak of the confirmation of charges phase or the confirmation of charges hearing, which takes place at the end. Well, there are many, many different steps in between which will take place, because once the person is here, and let's assume the person has been transferred to the court, he or she has been arrested, that person will be in detention. And then actually up until the so-called confirmation of charges hearing, after which the chamber will decide whether or not to confirm the charges, certain steps need to take place in order for this hearing and the decision to be conducted and to take place. One of the most important things that will take place is the so-called disclosure of evidence. That is, the prosecutor, who during his investigation has assembled, has gathered evidence, both incriminating and exonerating, he is under the obligation to disclose, to present, to show this evidence to the defense, to the counsel of the suspect, so that they can accordingly prepare the defense. So this is the biggest part of this preparation, of this pretrial preparation up until the confirmation of charges hearing. We have one deadline in this whole process, and that is 30 days before the start of the confirmation of charges hearing. Why is that date important? Because on that date, at the latest, the prosecutor will have had to disclose all the evidence, and for the purposes of the confirmation of charges hearing, and he will have to present a so-called document containing the charges, which is a document which enlists all the charges for which the suspect has been charged, has been accused of, and for which the confirmation of charges hearing takes place. So 30 days before that, the prosecutor will present this document. And as of that date, then, of course, preparations intensify a lot. Then the confirmation of charges hearing takes place. How long? It depends on the case. It depends on the issues that are crucial. It depends on the magnitude of the case, if it's a big case, if it's many charges, if it's less charges. In the Bemba case, we had a confirmation of charges hearing of 4 days. In the Lubanga case, it was, I think, in total 3 weeks. So you see, it varies a lot. And then after that, after the end of the confirmation of charges hearing, we have another further deadline of 60 days within which the chamber has to deliberate and write the decision whether to confirm or not the charges. And after those 60 days, the chamber issues that decision. And with that decision, in case the charges have been confirmed, then in that same decision, the chamber will commit the person to a trial chamber. Then actually we go from the pre-trial stage on to the trial stage.
To give you a practical example of how long does that take, this stage of the confirmation of charges. Lubanga case, Lubanga was surrendered to the court in March 2006. The confirmation of the charges, the decision was issued on 29 January 2007, 10 months, more or less. Bemba, the Bemba case. Bemba was surrendered to the court beginning of July 2008. The decision on the confirmation of the charges was issued on 15 June 2009, 11 months. So it's at least 8 months. In the Abu Garda case, he appeared, after a summons to appear, in May 2009. The charges were not confirmed in a decision of February 2010. So it's 7, 8 to 11 months, to give you an average.
Okay, thank you. One more question we have received from a journalist based in Eldoret. It says, what does preservation of evidence mean? When is it useful?
Well, that is a quite general question, and I would like to answer it in the following. Normally, the protagonist for the preservation of evidence is, of course, the prosecutor, because he starts the investigation. He's examining both incriminating and exonerating circumstances of a case, and he's the one collecting the evidence. So it's up to him to collect and to preserve the evidence. However, there might be instances where, in case of a unique investigative opportunity, that the prosecutor may approach the chamber and he may ask for the issuance of a specific order, because otherwise maybe this evidence could be lost, and to seek an order from the chamber in order to assist him to get this evidence. The same applies for the defense and the victims. So there is a small opportunity for the chamber to step in and to preserve evidence which otherwise would get lost for the purposes of a future trial.
Okay. Thank you. Now I would like to move to the rights of the accused, because we received 2 very important questions regarding these rights. First one is, please explain in general the rights of the accused once charged, i.e. bail, bond, remand. Please highlight the difference between the suspects and the accused person in this relation.
Well, let me start first by giving you an explanation between the suspect and the accused. The person will remain as a suspect until the charges are confirmed. Once the charges are confirmed on him, he is technically speaking an accused. Although the language of the statute is not very clear about that, in some instances the language uses person, and in some other instances use the accused. But the person for us is considered as an accused once there is an indictment confirmed against him, which in this respect in our statute is the confirmation of charges. The question of the rights of the accused or the person and in relation to the bail, etc., we are here speaking about, as I understand, as to his rights in terms of applying for interim release or provisional release, as we say. And the rights provided under the statute do go beyond the scope of provisional release and interim release. he has the right, once she is surrendered to the court, he or she is surrendered to the court, to apply for interim release and to request the relevant chamber to release him on certain basis with conditions or without conditions, and it's up to the relevant chamber at the time, of course, to rule on that. At any time, either the prosecutor or the person himself is permitted to raise an issue in relation to the detention of the person, and if the chamber found that the grounds on the basis of which the person's liberty was deprived no longer exist, then the person can be released. As I said before, he could be released with conditions or without conditions. If this did not take place, there is a duty imposed by the statute on the chambers to make a review on the person's detentions every 120 days. And this should take place in the absence even of a request from either the prosecutor or the person himself. There are other set of rights that are provided for the accused, and those are listed under Article 67 of the statute, and we consider them as minimum guarantees. Those are also enshrined in some human rights or the major human rights treaties. And this is, of course, the right to a public and fair hearing, the right to be tried without undue delay, the right to cross-examine witnesses, the right for free translation, interpreter, the right for legal assistance, etc. So those are mainly the major rights for the accused.
From which moment a suspect is entitled to a lawyer?
Well, from the very early moment, once the suspect is before the court, he can have his own lawyer, private lawyer, even before coming to the court. And that's not a problem. Once he's before the court and started at the initial appearance or something, he may be entitled to have a lawyer with him.
If he has no funds, that means the court would pay?
The court can provide. In some situation, the court can provide for legal funds. And that's one of the rights that are enshrined in 67.
Now, very interesting question. If accused is on bail and travels between The Hague and Nairobi for his case, does the ICC pay for their accommodation and travel expenses?
That's a very interesting question, but I'm afraid I cannot give a very general answer to this because it will depend on the specificities of the case and I suppose also on the indigence or not of the suspect. But as such, I'm afraid I cannot go further than that very general remark.
And one question which I often heard, and it's not on this list, is from which moment can ICC and why freeze the assets of a suspect person?
From the very moment there is the issuance of a warrant of arrest. This is Article 57, paragraph 3E of the Rome Statute. So the pretrial chamber, on its own motion, or at the request of the prosecutor, can request the assets of the suspect to be free, to be frozen.
Oh, thank you. Now we move to the question of witnesses. Is the prosecutor able to give judicial immunity, especially in regards to insider witnesses who may have participated in criminal activity?
Well, the answer basically is no. The prosecutor cannot give judicial immunity, at least he cannot do that alone. Because judicial immunity means, in this statute, in this court, to take a decision not to prosecute someone. Mm-hmm. In order to do that, the prosecutor has to notify this decision to the pretrial chamber. Oh. And the pretrial chamber has to agree with the prosecutor that this person is not going to be prosecuted. Otherwise, what the prosecutor is going to say has no value, because it doesn't take effect until and unless it is confirmed by the pretrial chamber. Actually, the prosecutor does not give judicial immunity to anyone because he uses another technique, which was described quite well at the beginning of the Lubanga trial, which is the statement of limited use. He doesn't say to someone, I'm not going to prosecute you. He simply says, whatever you're going to tell me, I'm not going to use against you, which does not mean that he will not prosecute that person. It simply means I will not prosecute you on the basis of what you tell me. But I could prosecute you on the basis of other evidence I have. This is what the prosecutor uses.
Oh, interesting. Then who decides on credibility of witnesses that are called to testify in a case?
The credibility of the witnesses is entirely up to the chamber to decide. It was because the witness statements were not very credible that the case in Abu Garda was not confirmed. Because actually, and the pretrial chamber explained that very well when non-confirming the charges, it said, well, when you read the witness statement, because people have to understand that at the pretrial level, we don't have the witnesses coming, we have the witnesses' statement, the pretrial chamber said, when you read the witness statement, in one part it said that, and in the other part it said the opposite. So that witness statement is not credible. Therefore, the case was not confirmed. The charges were not confirmed, and it stopped at the confirmation of charges.
Okay, thank you. We basically finished the most important and most frequent question that we gathered from journalists from Kenya and members of the civil society organizations. But now, is it possible just to give us an update? How many situations and cases we have before the court at this moment?
Well, at the moment, we have 5 situations before the court. 3, the Democratic Republic of the Congo, Uganda, and the Central African Republic have been referred to the court by the states themselves. The 4th situation, situation Sudan, Darfur, and the 5th situation is the situation of Kenya, where the prosecutor initiated, or he requested an authorization by the pretrial chamber to commence with the investigation. So these are the 5 situations. Out of these situations, the prosecutor, as has been explained previously by my colleague, Mr. Biti, the prosecutor identifies specific suspects who may later on become accused, as my colleague, Mr. Zaidi, has explained. So out of these situations, he identifies cases, specific suspects or accused. In the first situation, Democratic Republic of the Congo, the prosecutor identified 4 cases. The first one against Thomas Lubanga Diilo, the second against 2 suspects, Germain Katanga and Mathieu Ngunjolo Chui, the third case against Bosco Ndaganda, and the 4th case against Calixte Mbarushimana. The second situation, the situation of Uganda, there the prosecutor identified 1 case with initially 5 suspects, Joseph Kony, the leader of the Lord's Resistance Army, and 4 of his commanders. One of the commanders, the court received information that one of the commanders was killed. So proceedings against that person were terminated. So at the moment, we have 1 case with 4 suspects in the Uganda situation. The situation, number 3, concerning Central African Republic, there the prosecutor identified 1 case, the case against Jean-Pierre Bemba Gombo. The 4th situation, the situation of Sudan, Darfur, there we have at the moment 4 cases. 4. The first one against 2 suspects, against Ahmed Haroun and Al-Khushaib. The second case against Omar al-Bashir. The third case against Abu Garda, which stopped at the pretrial stage because the charges were not confirmed. And the 4th case against 2 suspects, Banda and Jerbo, whose confirmation of charges hearing will start on the 8th of December. The 5th situation, Kenya. There we are still at the investigation stage, at the situation level, because we don't have received yet any requests for warrants of arrest or summonses to appear. So there we are waiting for the prosecutor to approach the chamber with the respective requests.
Okay, thank you very much. And actually, I got the 2 questions related to the work of outreach. And the first question is, when the cases begin, how often we will get updates on the proceedings? Well, usually our practice is, which from another situation, is that once the case starts, we follow the proceedings and we make the judicial summaries every week, once a week. And these summaries will be available for uploads, and then further it could be broadcasted as audio and video file. And we will continue with this practice in situation in Kenya also. And the second question was, will outreach organize interviews with prosecutor whilst the cases are ongoing, or we have to go through OTP? Yes, all the requests related to the ongoing investigations, but also if you would like to interview prosecutor or someone from the office of the prosecutor, you have to go through Nicola Fletcher from the office of the prosecutor. And Finally, I would like to thank you very much for being and following us today, to showing your great interest in following this training. And once again, I would like to thank members of the pre-trial chamber. Thank them for coming, and I hope we will have this kind of session in the future on a more regular basis. Idea is once we move to next judicial phase, we have training, then every judicial stage we will follow up by trainings and our campaigns, different kind of campaigns. And this training will be available for download after this session, and I will send to all of you Q&A document which has been translated into 4 local languages. So feel free to use the document, and also you have our permission to republish it. Thank you very much.